I have two questions as well. The first is regarding the deductible costs. Are there any costs that you are deducing in all cases, or is it more like a case-by-case approach? That's the first question. And the second about aggravated damages. We don't have aggravated damages, but we could think about maybe we need, or I wanted to know how it works, let's say proportionally. Is it usually some smaller amount, or it could also be quite big amount?
Okay, so in answer to the first question about deductible costs, it's a case-by-case assessment. I explained the general principles to you in my talk earlier, but when you are looking about what costs can be deducted, it always depends on the specific facts of the individual case, and in particular, the way the relevant business works. And obviously, you need to distinguish between the scenario where it's damages and the scenario where it's an account of profits. If you're looking at damages, the question is going to be what profit the IP right owner is making from exploiting the intellectual property right. Now, you would appreciate that in those circumstances, the interest of the IP owner is to minimize the deductible cost, and the interest of the defendants is to maximize the deductible costs. By contrast, when you're looking at accounts of profits, it's the other way around, because the IP owner wants to minimize the defendant's deductible costs and the defendant wants to maximize the deductible costs. So those are the two litigation scenarios where you get the argument about deductible costs arising. But in resolving those arguments, you're always looking at the question of the individual business. So you're looking at the business of the IP right owner in exploiting the right, or you're looking at the business of the defendant in producing the infringing goods. And so you always have to ask, well, what is the financial situation of that business? And that's why it's very difficult to lay down generalized guidelines that go beyond what I've already told you as to what costs are deductible and what costs are not deductible. Because the answer is, it always depends on the way in which that business operates, the way it makes its profits, and the way in which the costs are generated in that particular business. And so to go back to one of the examples that I gave earlier, there's a big difference between what costs you can deduct if it's a single product business, which is just generating one product which is either protected by the IP right or is infringing the IP right, or if it's a multi-product business where you've got a whole spectrum of products, only one of which is protected by the relevant IP right and the other of which is not either protected or infringing that IP right. So it's always a case-by-case assessment. But the one thing that might be of use to you to add by way of a footnote to that point is to refer you to a website which some of you may have come across, which is known by the acronym BAILI, and that's BAILII, and that stands for British and Irish Legal Information Institute. And what the BAILI website does is it makes freely available to anybody with access to the internet all of the reserved judgments, that's to say the written judgments, handed down by the courts in the UK and in particular England and Wales. And it's a very useful website because you can access the judgments both by searching. It's got a very useful search engine that you can enter in your search terms to find relevant judgments, but also by browsing. So the judgments are listed by reference to court and year. So, for example, if you want to find all of the judgments of the Patents Court in 2019, you could go through the menu and you can find all of the judgments, the written judgments from the Patents Court in 2019, and they're listed in order. And if you go on the BAILI website, and in particular you look at recent decisions from the Intellectual Property Enterprise Court, you can find a number of decisions in concrete cases where these kind of issues are considered. So that's just a tip as to where you can find some useful information. Also, of course, you can find there's textbooks and so on. But if you want to find practical examples, that's quite a good place to find. Coming back to the second question on aggravated damages, the first point I would make is that, of course, there's no obstacle to the Latvian courts making orders of this sort. As I pointed out earlier, Article 13 of the Ip Enforcement Directive makes provision for moral damages, and I understand Article 13 has been implemented in your domestic law, and therefore you've got a basis for making orders of that kind. In answer to the question, as to the amount of aggravated damages or moral damages, it will depend on the nature of the case. There will be some types of cases, as I was saying earlier, where it will be a modest addition to the basic financial remedy. There will be other types of cases of which, the revenge pornography would be a good example, where most of the sum awarded will be for the aggravated damages or the moral damages, because it's not really about financial compensation. It's more about injury to feelings and things of that kind. So, moving on from there, I'm going to be talking about website blocking injunctions and streaming server blocking injunctions. So again, we're here in the realm of remedies rather than substantive law. However, in considering this area, we need to have a clear understanding of the basic conceptual framework of liability. Now, to explain what I mean by that, it is always important in any field of civil law, and indeed criminal law, but it is particularly important when dealing with intellectual property rights to distinguish between the possible bases of liability. And what I mean by that is that one can make a distinction between three fundamental bases of liability. The first basis is primary liability. This is where the defendant is himself, herself, itself, the infringer of the intellectual property right. That is to say, that person or entity has done the act restricted by the intellectual property right in question. Recall that intellectual property rights are negative rights. They're rights to stop other people doing things. So each form of intellectual property restricts the doing of certain types of act. If you do one of the restricted acts, you are liable for infringement, and that's primary liability. So copyright, as Thomas was explaining to you earlier, one of the restricted acts is communication to the public. So if you communicate to the public, you are an infringer, that's primary liability. So that's our first basis. Our second basis is accessory liability, sometimes also called secondary liability, also called sometimes contributory liability. But I prefer the term accessory liability because I think it's clearer what we're talking about. So this is the liability of someone who does not themselves do the infringing act, but they are accessories. That's to say they help someone else. They assist someone else. And most systems of law have a conception of accessory liability. And this will be true both in civil law and in criminal law. And the same is true of most systems of intellectual property law, is you would have liability on the part of those who are not themselves doing the infringing act, but who are helping other people to do them, who are involved in the infringement in some indirect way. Now, in the context of EU law, an important point to understand is that when we are talking about primary liability, there's a great deal of harmonization of EU intellectual property law. So you've been learning yesterday and today about a lot of, in particular, about copyright law, which, as has been explained to you, is substantially harmonised. We've got 13 directives now harmonising copyright law across the EU. So it's not quite true to say that all of copyright law is harmonised. It's not, but an awful lot of copyright law is now harmonised. But it's harmonised at the level of primary liability. The same is true of trademark law and designs law. Again, a substantial degree of harmonisation across the EU, but it's at the level of primary liability. When it comes to accessory liability, there is zero harmonisation, nothing. Not only that, you find out when you inquire into this question that not all legal systems in all EU member states have any doctrine of accessory liability for intellectual property right infringement. Now, coming from a country where we've had accessory liability for intellectual property right infringement for hundreds of years, I find this very surprising. But it is a fact that some member states, their legal systems do not recognise any doctrine of accessory liability for intellectual property right infringement. I find that baffling, but I'm assured that it is so. Now, this has important consequences in terms of the operation of European law. Why is this so? Answer, because when you look at the decisions of the Court of Justice in intellectual property cases, and you see this most strongly in the copyright cases, which have been mentioned yesterday and today, what you see is that the Court of Justice is faced repeatedly with cases raising questions which in truth are questions of accessory liability. But the Court of Justice knows full well that accessory liability is not harmonised, and therefore the court can't go there. And so what you find time and again in cases like the Pirate Bay case, the Filmspieler case, and so on, is you find that the court giving answers to questions which are about primary liability, where the court imports into its answer considerations which in truth are considerations of accessory liability. So when you read the case law of the Court of Justice, and as I say, it's particularly in a lot of these recent copyright cases, bear in mind that although the court purports to be telling you the law about primary liability, what's really going on when you look beneath the surface is that a lot of it is really about accessory liability. And what is happening very, very slowly is that the court is creating, step by step, an EU doctrine of accessory liability for intellectual property right infringement. It's just that they can't tell you that that's what they're doing, but that's the reality of it. Now, I've told you about two bases of liability, primary and accessory. But I told you earlier that there were three. What's the third? The third basis is intermediary liability. Now, this is a system of liability that, again, not all legal systems have. So in English law, this was something that in the past was entirely foreign to us. We knew nothing about it. But some systems of law have had this for many years. So the classic example is German law. German law has a doctrine known as Störerhaftung. And this is a conception of liability which is distinct both from primary and accessory liability. But when we come to the EU law, we find that although accessory liability is not harmonised, intermediary liability for intellectual property right infringement is harmonised. And this is very important. Now, what do we mean when we talk about intermediary liability? So this is the liability of intermediaries, even though they are not liable either for primary infringement or as accessories. So you need to be very clear in your minds here that we're dealing with a form of liability which applies even if there is no primary infringement and no accessory liability for infringement. Not only that, the other key point to appreciate is that intermediary liability is fundamentally different from both primary and accessory liability. In this way, it is forward-looking, it is not backwards-looking. What do I mean by that? If there is someone who is liable either for primary infringement or liable as an accessory, they are liable to a financial remedy for the past, so damages or an account of profits, and they're liable to an injunction to restrain infringement in the future. So the liability for both on the primary and accessory side is both for the past and for the future. It's backwards looking and forwards looking. By contrast, intermediary liability is not about the past. There is no liability for whatever happened in the past. It's forward-looking only. It is only about the grant of an injunction to change behaviour in the future. And this is why intermediary liability is so important, because what it gives is the potential for a right owner to get an injunction against intermediaries with regard to future behaviour. Now, the next thing you need to bear in mind is the distinction between negative injunctions and positive injunctions, prohibitory and mandatory. So an injunction may be to tell someone not to do something in the future, that's negative or prohibitory, or it may be an injunction requiring them to do something in the future, that's a positive or mandatory injunction. Now, for practical reasons, as you will discover in a moment, when we're talking about intermediary liability, we're usually talking about positive mandatory injunctions. This is all about getting intermediaries to do things in the future. This is a positive requirement on them. Okay, so with that introduction to the conceptual background, let's then turn and look at the legislation. So the legislative basis for intermediary liability with respect to intellectual property rights in the EU and the UK is as follows. We start with the Information Society Directive, or the InfoSoc Directive for short, of 2001, and Article 8.3 says that member states shall ensure that right holders are in a position to apply for an injunction whose services are used by a third party to infringe a copyright or a related right. So, you see from that it's about injunctions, not damages, as I was explained to you. It's about people who are intermediaries, and that's despite the fact that they may not be infringing either on a primary basis or an accessory basis. But their services are being used by someone else to infringe a copyright or related right. Now, at this point, you might be asking yourselves, well, what's the rationale for this form of liability? And this is what the economists call lowest cost avoidance. So there's an economic theory behind this, which says that there are certain situations where, economically speaking, the lowest cost way of dealing with infringement is by requiring an intermediary to take steps. Whether that economic theory is sound or not is highly contested. Some economists will tell you it's sound, other economists will tell you it's not sound. I'm not an economist, so I won't enter into that debate. But what I can tell you is that from the right holder's perspective, regardless of whether or not it's good economists, it has a practical advantage. Because for the reasons that Thomas has explained to you, what you find in the online world of infringement is that frequently you have real trouble finding a defendant who you can sue, who's in your jurisdiction, and who you can make primary liable or accessory liable. Frequently, as Thomas has illustrated to you this morning, the real perpetrators are outside the jurisdiction, and they're using technical facilities which are, located in Tonga or wherever it may be. So you have a real practical problem in enforcing your rights against the primary infringers and even the accessories. And the advantage of intermediaries is that there will be an intermediary in your jurisdiction. And so you can go after the intermediary, and it's a much more practical way of enforcing rights. So those are the two possible rationales for this form of liability. There's the economic theory, or there's the practical approach. Now, in terms of implementation in the UK, I'm going to tell you a little bit about this for reasons that will become apparent. The way in which we implement EU directives in the UK is that we have something called the European Communities Act 1972, which allows the government to amend the law to comply with an EU directive. And this includes amending acts of parliament. And this is what underlies the whole Brexit debate, because the Brexiteers hate the European Communities Act 1972 because it's contrary to our notion of parliamentary supremacy. It gives effect to the primacy of EU law in the UK. And so the objective is to not only to have UK withdrawal from the EU, it's also to repeal that act so as to restore absolute parliamentary supremacy. So what happened in this scenario was that the government amended the Copyright Designs and Patents Act under the European Communities Act 1972 and 2003 to insert a new provision to give effect. And as I was explaining yesterday, at that period of time, the practice in the UK was not copy and paste implementation, rather to refine the wording, because that was thought at that time in the UK to be a good idea. So the way the wording was refined in this particular instance was that Section 97A, subsection 1, says that in the High Court or in Scotland, the Court of Session shall have power to grant an injunction against a service provider where that service provider has actual knowledge of another person using their service to infringe copyright. So you'll notice that that's actually rather different, both in terms of wording and in terms of substantive content, to what Article 8.3 actually says. And the rationale for that I don't have time to explain, but there is actually a rationale for it. Now, something then very odd happened, which was this. In 2004, at the EU level, we had the horizontal measure, the Ip Enforcement Directive, which harmonised remedies and procedures for enforcement of intellectual property rights on an EU level. And specifically, so far as we are concerned, Article 11, third sentence, generalised what was in Article 8.3 of the Infosoc Directive to all IP rights. So Article 8.3 of the Infosoc Directive was just about copyright and related rights, but now we have Article 11, third sentence of the Enforcement Directive, which says Member States shall also ensure that right holders are in a position to apply for an injunction against intermediaries whose services are used by a third party to infringe an intellectual property right. So this now applies to any intellectual property right, although note there is no definition in the directive of what is and what is not an intellectual property right, and I'll come back to that. Very oddly, in the UK, despite having had a specific statutory implementation of Article 8.3 of the Infosoc Directive, the government then took the view when it came to implementing the Enforcement Directive, they didn't need to do anything. They said, we think actually our law already complies with this requirement, we don't need to do anything. Very, very odd. But anyway, that was, as it turns out, the court said they were right. But how they knew that at the time is a bit of a mystery. Okay, so we've had a bit of a history with this form of relief in England and Wales in particular, bearing in mind that the UK is a number of different legal jurisdictions. We have England and Wales, we have Scotland, we have Northern Ireland, and even England and Wales are diverging from each other, but that's another story. The first website blocking injunction was granted by me back in 2011 in a case called 20th Century Fox and British Telecommunications, or BT for short, also known as Newsbin 2, that being the name of the website in question. And this was very much a test case. and some copyright owners who were the film companies came to court saying, here's this infringing website, and please grant an injunction requiring the internet service providers, the internet access providers, to stop access by their subscribers to this website. So now you can understand why the right owners think this is a practical remedy. They'd already, by this stage, sued the operators of the website and had a finding of infringement, but they couldn't get an injunction that actually had any practical effect because the website was hosted abroad. So having failed to get any practical effect in their claim against the operators of the website, they then turned around and said, all right, please make an order against the internet access providers to block access by all the UK customers to this foreign hosted website. So that they thought would give them a practical remedy. And I went through a whole load of issues, wrote a long judgment, and eventually concluded that I had jurisdiction to make such an order and that it was right to do so. One of the very odd things as a matter of history about that case was that although it was everybody treated it as a test case, and I gave permission to appeal to the Court of Appeal to both sides, because although my decision was largely favourable to the copyright owners, it wasn't entirely favourable to them on certain points. Nobody appealed. Don't ask me why. And then subsequently, there were a series of other cases, another 15 copyright cases, in which injunctions were granted against over 250 infringing websites, including the one that Thomas told you about earlier, the Kick-Ass Torrents. That was one of them. And these were all on unopposed applications. That is to say, the copyright owners were coming to court, saying to the court, please grant one of these website blocking injunctions, and the internet access providers were not opposing. But of course, the court still had to be satisfied that it was a proper case, because these injunctions affect third parties, and in particular members of the public. So I wrote a series of judgments on unopposed applications explaining why I was making these orders, and a couple of my colleagues also heard these type of cases and also were persuaded to do so. Then came along a case called Cartier and Sky, and this was different because in this case the right owners weren't relying upon copyrights, they were relying upon trademarks, and they were saying, here we are, this is Cartier watches and jewellery, and there are all these websites selling counterfeits, and we want an order blocking access to these websites selling the counterfeit watches and jewellery. And so, again, I had to consider this, wrote another long judgment, and decided again that it was appropriate to grant a website blocking injunction on the basis of trademark infringement. And again, I gave permission to appeal. And this time, unlike the previous time, the ISPs did appeal against the injunction to the Court of Appeal. And on one point, they also went to the Supreme Court. And the effect of the decisions of the Court of Appeal and the Supreme Court is to confirm the jurisprudence built up at first instance in copyright cases since 2011, save with respect to the costs of implementing the injunction, which I'll come on to in a moment. So where do we stand now? It's now established that the courts of England and Wales have jurisdiction to grant website blocking injunctions to combat trademark infringement and, by implication, any other relevant right, despite the absence of any legislative implementation by the UK of the third sentence of Article 11 in the Enforcement Directive. And the Supreme Court held that it turned out, according to the Supreme Court, we had this power anyway. And so what the government said when implementing the Enforcement Directive turned out to be correct, and what the view that they took when implementing the InfoSoc Directive, that there needed to be a specific statutory implementation, turned out to be wrong. And they said, we have this power applying what was described as the ordinary principles of equity. This is judge-made common law in our country. And as Lord Sumption, who gave the leading judgment, said, orders for disclosure information, which is a very common type of order that we make, are only one category of order which a court may make against a third party to prevent the use of his facilities to commit or facilitate a wrong. So you will see it's a very broadly expressed power. We have the power to make orders against third parties requiring prevention of the use of their facilities to commit or facilitate any wrong, and I'll come back to that later. Moreover, despite that, it's established that the court's jurisdiction is adequately prescribed by law. Although it's not in statute, case law is good enough. So we comply with the European Convention on Human Rights and the EU Charter on Fundamental Rights. Now, in deciding whether to grant such an injunction, there are 4 threshold conditions that the right owners must satisfy in order to open the jurisdictional gateway. And there are 4 of them. Firstly, that the defendant is an intermediary. Secondly, that the users and/or operators of the website are infringing the claimant's rights. Thirdly, that those users and/or operators are using the defendant's services to infringe. And fourthly, the defendants have actual knowledge of this, which may be as a result of being notified by the right holder. Now, if you ask where do those 4 threshold criteria come from, the answer is as follows. 1, 2, and 3 come straight out of the face of Article 11 of the Enforcement Directive. It's all there in the text. The 4th threshold requirement doesn't come from there, but you will notice that the wording there echoes Section 97A of the 1988 Act that was inserted when implementing Article 8.3 of the Enforcement Directive. Where does this requirement of actual knowledge come from? Answer, it comes from the e-commerce directive and the various safe harbours that exist for intermediaries under the e-commerce directive, the effect of which, as Thomas showed you by reference to Article 14, is that intermediaries are immune unless they have actual knowledge. So that's where the 4th threshold condition comes from. Now, suppose the threshold conditions are satisfied, thus opening the jurisdictional gateway to the grant of an injunction against an intermediary. Then the court has to consider whether it's appropriate on the facts of the individual case to grant an injunction or whether not to grant an injunction. And in order to decide whether an injunction should be granted, there are a series of 8 criteria that the court needs to consider. The injunction must be necessary, effective, dissuasive, not unduly costly or complicated, avoid barriers to legitimate trade, be a fair balance between the fundamental rights engaged, proportionate and safeguarded against abuse. Again, you may ask, where do these criteria come from? The answer is that almost all of them come from the wording of Article 3 of the Enforcement Directive, which sets out general criteria for the grant of remedies when it comes to intellectual property cases. And this afternoon we're going to be talking about remedies in injunctions in patent cases, and I'll have something to say in that context about this issue. The one thing that doesn't come off the face of Article 3 of the Enforcement Directive is requirement 6, which is striking a fair balance between the fundamental rights that are engaged, and that comes from a whole list of cases in the Court of Justice, such as the L'Oréal and eBay case, which was one of my 15 references. And if you look at L'Oréal and eBay, one of the things that the Court of Justice had to say in that case was that injunctions under Article 11 must strike a fair balance between the fundamental rights which are engaged. So that's where that one comes from. Now, if you work through these criteria systematically, what you find is that proportionality is the key one, because consideration of the other factors feeds into the proportionality analysis. Now, when we consider the proportionality of such an injunction, An important consideration is the nature of the technical measures which the ISPs are required to adopt, and hence their efficacy, costs, and impact on lawful users. And the practice in England and Wales, ever since the first case, the Newsbin 2 case, has been for the court's order to specify in detail the technical measures which the ISPs are required to implement in order to comply with the order. This is not the practice in all member states. Some other member states, a notable example is Austria, do not require that to be specified in their orders. But in England and Wales, we think this is important because unless the court knows what technical steps are going to be taken, it's very difficult to assess their proportionality. Now, a point that is often raised in discussions about these kind of injunctions, these website blocking injunctions, is that they're pretty easy to circumvent. Yes, the ISPs can put technical measures in place to block access by their subscribers to infringing websites, but it's really easy, if you know what you're doing, to circumvent them. So there are things called virtual private networks, proxies, mirror sites, various techniques are available. And if you do a quick search, you can find out very quickly how to circumvent these blocks, and it's easily done. So quite a lot of people say, well, what's the point when it's so easy to circumvent the blocking order? And the answer is that experience shows that actually it does have an effect. If you read the judgments that I produced in some of the later cases, particularly the Cartier case, I go through the evidence that was produced. And the evidence shows that these orders are effective in reducing traffic to targeted websites. They don't stop it altogether, but you get a substantial reduction. And whether the extent of the reduction warrants the costs of the injunction, if and to the extent that they're borne by the ISPs, and any impact on lawful users, is a question of proportionality and, of course, the fair balance. And what happened in the Cartier case is that a big part of the argument by the ISPs was to say we shouldn't grant a website blocking injunction because there are alternative remedies which the right owners could adopt. And both I and the Court of Appeal went through about 8 other measures that were proposed by the ISPs as being alternative remedies. And both I and the Court of Appeal came to the view that none of these alternative measures would be as effective as a website blocking injunction. And so therefore we agreed with the right owners that the website blocking injunction was a worthwhile remedy because it was more effective than the alternatives that were available to them. Another practical point is that in England and Wales, there is no requirement for the right owner to sue or to attempt to sue the website operators first, or even to prove that it would be pointless to try, as is required by the jurisprudence in some other member states. Another important practical point is that the orders are what is sometimes called dynamic. That is to say, they enable the right owners subsequently to notify to the ISPs any other IP address or URL, as the case may be, whose sole or predominant purpose is to provide or facilitate access to the target website, which must then be blocked. So there's both an opportunity and a requirement for the order to be updated on a continual basis. And this is essential for the practical operation because otherwise these orders would be instantly circumvented and rendered completely useless, because all that would happen would be that the operators of the target websites would just change the URL or the IP address, and the injunction would be completely pointless. So you need to have them updated on a regular basis. And our orders in England and Wales enable that to be done consensually between the right owners and the IP orders. In the event of a dispute, of course, they can come back to court, but they don't have to come back to court to get the order changed every time the website changes its IP address or URL. There are various procedural safeguards that are incorporated in the orders. For example, the ISPs can apply to set aside or vary the order in the event of a change of circumstances. Users can also apply, website operators can also apply, and information about the block must be displayed at the website. Finally, there's a sunset clause, meaning that the injunction expires. And typically that's 2 years, but then the right owner can come back if they want to. Now, the issue that went to the Supreme Court in the Cartier and Sky case was who should pay the costs of implementation. And the practice that had been adopted by my court in the copyright cases prior to Cartier and in the Cartier case was to order the right holders to pay the costs of an unopposed application and subsequent monitoring, and to order the ISPs to pay the costs of implementation and subsequent updating. And then the ISPs were also ordered to pay the costs of contesting the application in both Newsbin 2 and Cartier. So the effect of that regime was to share the costs between the right holders and the ISPs. So all the costs of evidence gathering, persuading the court that it was appropriate to grant the injunction, were borne by the right holders. Likewise, the monitoring costs after the injunction was granted, that too was borne by the right owners, but the actual costs of implementation, which were quite small, were borne by the ISPs. The Court of Appeal upheld that order by a majority. The Supreme Court disagreed. They said that the right holders should pay the marginal costs of implementing the injunction and subsequently updating it, although otherwise they agreed with the cost orders that had been made by the High Court. And if you look at the reasoning consists of 3 elements. First of all, they said, well, look at recitals 59 of the Infosoc Directive and 23 of the Enforcement Directive, and that leads the question to national law. Then they said, well, these ISPs, they're intermediaries, they're innocent, they're not infringers, they're neither primarily liable nor liable as accessories, and therefore they're legally innocent. And they thought there was a close analogy between other situations in which we grant orders against parties who are legally innocent, such as provision of information, that's what we call Norwich Trust, information from banks, we call that Bankers Trust, freezing orders. These are all situations where we order compliance costs of innocent parties to be paid by the applicant, although in those scenarios, those costs are always recoverable from the wrongdoer. And one of the problems with intermediary liability with IP infringement is that the right owners can never recover the costs from the wrongdoer. Interestingly, when you look at the Supreme Court decision, 2 factors which are simply not mentioned and therefore I don't believe were argued in the Supreme Court is that ordering ISPs to pay the implementation costs has 2 advantages. Firstly, it avoids the need to quantify the marginal costs and therefore avoids evidence and argument on that issue. Secondly, it gives ISPs an incentive to be efficient, to innovate and to cooperate with right holders. But as I say, those points don't seem to have been made by the right holders in argument before the Supreme Court. So the most recent development in the field of website blocking injunction is a decision of mine on the 10th of September. And this was a case involving an application for a website blocking injunction by Nintendo. And they wanted me to grant a website blocking injunction requiring the ISPs in the UK to block access to 4 target websites which were advertising, offering for sale and selling devices and software for circumventing the technological protection measures protecting Nintendo Switch video games consoles. And this is another area of big business. Producers of video games like Nintendo, they all have their own consoles which are sold, and they all have hardware and software in them which are designed to stop them being hacked, as it's put, by third parties to enable pirate video games to be played on them. And there's big business for people who supply circumvention devices and pirate games. And Nintendo wanted to block access to 4 websites that were particularly big in supplying these circumvention devices. And they based their claim on 2 basic forms of right. Firstly, EU trademarks, so that was a precisely parallel with Cartier and Sky, but also they relied upon rights conferred on Nintendo pursuant to the UK implementations of Article 6 of the Infosec Directive and Article 7.1c of the EU Software Directive against advertisers and so forth of circumvention devices. Now, slightly curiously, Nintendo accepted that their anti-circumvention rights were not intellectual property rights within the meaning of the Enforcement Directive. I told you earlier, when you look at the Enforcement Directive, there's no definition of intellectual property rights, and Nintendo conceded that whatever the definition was, anti-circumvention was not within it. They could well have argued to the contrary, it seems to me, but they chose not to do so. But they said, nevertheless, it doesn't matter, because even assuming that these rights are not IP rights, on the basis of what the Supreme Court said in the Cartier and Sky case, you've got jurisdiction anyway, and it seemed to me that was right. And so therefore I made the order both on the basis of trademark infringement and on the basis of these anti-circumvention rights. Another recent development is something that Thomas referred to, which is streaming servers. So when we're talking about website blocking, we're talking about blocking static websites. So there's a website there, and of course it may change from time to time, but at any 1 second, it's static. So you're just blocking access by the subscribers to that website. But as Thomas has explained to you, a lot of infringement these days, particularly copyright infringement, is all about infringements involving live streaming. So typically this will be sports broadcasts, although there is also the phenomenon of stream ripping as well. And in this scenario, what the right owners want to do is to block access to the streaming servers from which the infringing streams are coming. And in principle, there's no difference to website blocking, but the actual, in terms of the technicalities of it, because again, at the end of the day, what you're doing is blocking access to a particular IP address or a particular set of IP addresses. So from a technical perspective, it makes very little difference. But of course, one needs to consider the legal basis for it, as Thomas has explained to you. The interesting thing about these types of orders is that they demonstrate how far the technology has advanced. Because what has happened in these cases, which have been going on since July 2017 when I granted the first of these injunctions, is that the orders have required the ISPs to block the IP addresses of streaming servers used to stream infringing copies of live broadcasts of football matches and boxing matches. And the way in which they work is that the orders set out criteria, some of which are confidential, for compiling on a rolling basis a list of servers which are to be targeted. And then these servers are targeted and blocked only for the duration of each match. So the technology that the ISPs have is now sufficiently sophisticated that they can turn on the block when the match starts and turn off the block when it stops. So it's highly targeted, highly sophisticated. It's quite amazing what they can do. And in addition to the usual safeguards, the hosting providers which host these servers can apply to set aside the orders. And the evidence has shown that these orders are very effective. They're actually more effective than the website blocking injunctions because you're stopping the infringement one step further up the chain. You're closer to the source. And for that reason, it's actually more effective. There have been some circumvention attempts which have led to the orders being modified to ensure continuing efficacy, but as we speak, I think the evidence is that they're still quite effective. Curiously, the parties in all of these cases have managed to agree what happens with costs, but not told me what the agreement is, so I don't know. All I know is that what they've agreed is that there should be no court order. What private agreement there has been, I know not. But I'm sure that there is one. So, that's where we stand at present. Any questions?
Thank you so much for this excellent presentation. Lūdzu, jautājumi? Yeah.
Thank you very much for a great presentation. I have a question regarding actual knowledge. Does it mean that right holders must first go to the ISP, or they may directly raise a claim in the court, or maybe other way around to ask whether the ISP may block a site without court order?
Well, that's two different questions. So far as actual knowledge is concerned, in principle, an ISP could have actual knowledge without notification. So take Pirate Bay. I mean, Pirate Bay was notorious. So I'm quite sure that all the ISPs had actual knowledge about Pirate Bay, regardless of whether they were told about it. But as a matter of practicality, what happens, certainly in England and Wales, is that the right owners notify the ISPs and in that way make sure that they have actual knowledge. As to whether the ISPs could block access without a court order, I think that's an interesting question, but it's not of any practical relevance, and I'll explain why not. It's not of any practical relevance because they don't do it, and they won't do it, and that's for their own self-protection. If they blocked access without a court order, then they would be at risk of being sued by their customers. And so they insist upon having a court order because it gives them immunity from any claim by their customers, because their answer to any claim by the customers is to say, we're obeying the court order, and therefore what we're doing is lawful, even if it's a breach of contract with the customer.
Well, in Latvia, I think it's a bit maybe different because some of largest ISPs are at the same time distributors of the content, so they have interest to block themselves.
Well, that's true. So in some of the Striving cases, that was exactly true. So particularly the live Premier League matches, as it turns out, several of the ISPs in the UK are part of conglomerates that have big interests in exploiting broadcasts of Premier League football matches. So they had a financial interest in the order being granted. And they made that clear. They were completely open and candid about it. And so they positively supported the court making the order, but nevertheless they didn't do it without a court order for the same reason.
Okay, and one more question about proportionality, and not in the terms of costs, but let's say I will explain for instance, when there is let's say platform offering well, I don't know, thousands of works protected by copyright, and then there is a right holder who asks to block because of one or two works placed on this platform without permission of right owner. Well, does that matter how many works of works placed in platform are proved to be pirated, or maybe you classify the whole platform as a pirate one?
So this is at the centre of the debate on proportionality, because as you all understand, in this context, we've got a number of different interests in play. We've got the interests of the IP right owners. So their IP rights are required to be protected under Article 17, paragraph 2 of the EU Charter of Fundamental Rights. Then we've got the interests of the ISPs and their interest in carrying on their business, which is protected under Article 16 of the EU Charter of Fundamental Rights. You've also got the interests of the website operators and their right to carry on their business. And that depends, of course, to what extent it's an infringing business, because if it's an infringing business, then it has no lawful existence. But if, to the extent that it has a lawful existence, then it has to be taken into account. And you've got the interests of the users, and in particular their right to receive information protected by Article 17 of the EU Charter. So hence all this jurisprudence from the Court of Justice telling us about striking a fair balance between all these fundamental rights that are engaged. Now, when we look at the interests of the website operators, as I've already said, a fundamental consideration is to what extent it's a lawful business and to what extent it's an illegitimate business. And one of the key considerations, as your question rightly identifies, is to what extent they're hosting infringing content and to what extent they're hosting lawful content. And one of the arguments that's always presented in these cases is, oh, well, you shouldn't block access to this website because there's some lawful content. Now, all the cases where that argument has been raised in England and Wales so far, it's failed on the facts because it's turned out that when you looked at the website in question, it was almost all infringing. The proportion of lawful content was tiny. And of course, if the proportion of lawful content is tiny, you don't worry about it. But the hard case is where you've got a substantial proportion of lawful content. Now, the answer to that is it may depend on to what extent you can target. Because if you can target so that only access to the illegitimate content on the website is blocked and not the lawful content, and these days the technology will sometimes allow you to do that, then you don't need to worry. And that's why the streaming server cases are so wonderful, because with those, you only block for the duration of the match. So you're only blocking for a very limited period of time, and anything that goes on the rest of the time is not blocked.
But you block all the platform, or you block just particular translation?
Yeah,
broadcaster.
You block the source. You block the source.
So the whole platform, yeah.
Yes, but only for that duration in time. And of course, you know that if it's a Premier League football match, most of what's coming during that time window is infringing. So, this can be a sensitive and difficult issue, but in practice, in the cases that have come to court in our jurisdiction so far, it's always been pretty clear.
Well, but I have then a procedural question. You said that that you see that the most content is pirated, yeah, then there is no question. There is the same injunction, but. So claimant provides this evidence, or
yes,
because for instance, we had to my knowledge one case just, and there was evidence on that there are two movies on the particular platform are infringing, and nothing else.
I would say that's not good enough. If they came to me, I would say go away, come back with more evidence that there's a substantial proportion of infringing content. I mean, you can't block access to a whole website just for two movies. That's plainly disproportionate.
That was the case. And another question, well, that was also appeared in this one case, that, ISP was willing to block. They said, okay, we will block. If I understood correctly, you are not inviting like Danish courts, or you're not informing the site which you are going to block. Probably they are not participating in proceedings, or not.
So it's not a requirement, but usually what happens is that when they're applying for the order, the right owners produce evidence that they've contacted the operators of the target websites and asked them to stop and have been ignored. And usually there's also evidence to show that it's hosted abroad, etc., etc. And often there's evidence that the operators are using pseudonyms. And so, as a practical reality, it's absolutely impossible to get any cooperation from the operators of the target website. But we say very clearly it's not a requirement to produce that evidence. In most cases they do, but it's not a requirement.
Okay, thank you.
Paldies, vēl kādi jautājumi?